Welcome back to Law and Crime, folks. We're going to take a quick break away from the Roy Oliver case in Texas to talk about two big cases that cut very close to the Trump White House. Those cases are the cases of Paul Manafort and Michael Cohen. Let's start to break them down. Michael Cohen, of course, President Trump's former personal attorney. He pleaded guilty yesterday to 5 counts of tax evasion, a count of filing a false statement with regards to a credit decision, and also 2 counts of making excessive campaign contributions. Those are the counts to which Michael Cohen pleaded guilty. He said that he made excessive campaign contributions. Those were payments related to 2 women who claimed that they had extramarital affairs with President Trump. Cohen said that he arranged those payments at the request of the federal candidate himself, and there is no concern whatsoever that that is anyone other than Donald Trump. So that's the Michael Cohen case in a snapshot. Also yesterday, a guilty verdict from a federal jury on 8 of 18 charges for former Trump campaign manager Paul Manafort. Those charges involve tax fraud, bank fraud, and failure to properly register and file documents pertaining to a overseas bank account. We're going to bring Gene Rossi into the conversation. He's a former federal prosecutor joining us here on the Law and Crime Network. Mr. Rossi, welcome to Law and Crime.
Oh, thank you so much.
I know that you've been writing a lot about this case, and it's a case that so many people are following very closely. It's where law and politics intersect. It's been tough to try to separate the two because whenever you have something political, there are ideological camps attached to it. But purely as a legal matter here, how do we make sense of the Manafort situation? Where does this go from here?
That's a very good question. First off, the magic number for both cases is 58. 8 counts, 5 of tax. You had 5 counts of guilty in Manafort for tax evasion or tax fraud, and then the other 3 counts involved bank fraud and FBAR, and of course Michael Cohen. Where we stand, the government has until the end of August to decide whether to retry the 10 counts that are hung. And I got to stress that we do not know what the vote was on those hung counts. It could have been 11-1 for acquittal or for conviction or somewhere in between. The next step for the government is to make that big decision. If I were in that office, I worked there for 20 years, I was in front of Judge Ellis over 500 times, 7 trials, I would dismiss those 10 counts. If you think Judge Ellis was tough on the prosecutors this first trial, I don't think he would be happy if the government tried to retry those 10 counts. So those counts are probably going to go away. The next step for the defendant is appeal. But what I want to stress is this. Kevin Downey, who's from the Department of Justice Tax Division, where I used to work, and I know him, 2 of his fellow attorneys, and then some of the prosecutors, Kevin Downey said he's going to keep all options open. What does that mean? It means one of several things. He is going to appeal to the Supreme Court the conviction. He is going to fight like you know what in D.C. on the second trial, and he's going to hope for maybe a pardon or a commutation. Or another option is this. I never thought I'd be saying this. There is a fair chance that Paul Manafort may say, Mr. Mueller, you got me. I can't fight anymore. There are too many battles. I'm running out of money. I'm a beaten man. I'll cooperate. And if he cooperates, he has a treasure trove of potential information that could help the Mueller office, because Rick Gates is also cooperating on not just the Paul Manafort stuff. He's cooperating on many other matters based on a sidebar that is now under seal, and I think that's what they said, the prosecutors. So that's where Manafort stands. Both sides did a great job. The defense did the best they could, but that's where we go with the Manafort case.
Yeah, okay, so let's talk about the Rick Gates testimony here, because
Yes.
he was the key witness. He was the former partner to Paul Manafort. A lot of people are saying that the counts that the jury hung on related to a lot of the Gates testimony. Is it possible that jurors sat back there and said, hey, you know, we don't really trust this Gates character? Is that your assessment of this, or is that just complete speculation?
No, I actually thought you were going to ask me that question.
Okay.
Rick Gates testified August 6, 7, and 8, Monday, Tuesday, Wednesday. I was there in the courtroom watching it or in an overflow room. And I got to tell you, I was with the Department of Justice for 30 years. I thought Rick Gates took some hits on cross, but overall, he was a very net plus for the prosecution. I thought his direct exam was solid. I thought the redirect was solid. He did take some hits, especially on the embezzlement and an affair with a paramour in London. So, but we don't know, sir, what their vote was on those other 10 counts. It could have been 11-1 for guilt, 10-2 for guilt, which isn't bad. And that would suggest that, Rick Gates had some problems, but he was corroborated. The other theory is they thought Rick Gates was terrible. I think it's somewhere in between, and here's why. Paul Manafort was found guilty of 8 counts, and Rick Gates, in his 3 days, provided a lot of information about the 5 tax counts, the F-bar count, and also the 2 bank fraud counts that were convictions. So I think they thought that Rick Gates had his problems, but they found corroboration through documents or the other witnesses that said, you know what? He is a liar. He's a cheat. He's an embezzler. He did some bad things. But on these topics, he was correct. I called a lot of drug dealers, okay? They lied like crazy. But juries, when they saw him in that witness box, they drew a different conclusion. I, in fact, I had 2 trials where I had to call 3 people convicted of perjury. And I can tell you in those 2 trials, the defendants were found guilty, and those 3 witnesses, even with the perjury convictions,
were credible.
Were credible because the jury saw their demeanor and their testimony was corroborated by documents and other witnesses.
By other evidence. I want to move on now, Attorney Rossi, to the Cohen case. Now, we want to make sure we get some discussion of that, and we've got a little bit less than 2 minutes left here. Michael Cohen, former personal attorney to President Trump, admitting guilt on, I think it's a total of 8 charges here. Okay, the key language coming out of this is that he made those payments at the request of the candidate for federal office himself. And there seems to be no discrepancy, no question that he's talking about someone but President Trump. What does this mean for the White House?
All right. First off, I represent a significant potential witness in this matter. So I have to be very careful about what I say. I will make comments on what's in the public record and what happened publicly in the hearing. So I can't talk about my client.
Understood.
Okay, so in the court hearing yesterday and in the documents filed in court, Michael Cohen, he used some language that suggests that the President of the United States, you can use all the language you want, but at the end of the day, he essentially, and the prosecutor too, in her allocution for the plea, suggested that Mr. Trump is an unindicted co-conspirator because he, Mr. Trump, and Michael Cohen and others on that side of the equation, they negotiated payments, and they were well aware that those payments were close to the election and were influenced by the election, and they violated the campaign caps for campaigns, and that was all to conceal 2 individuals who may have had negative information about Donald Trump. What was your other question, sir? I'm sorry.
I think, the ultimately how close does it cut for the White House here? Because, when we start talking about this campaign contribution things, we've got Supreme Court precedent that seems to be opening up the floodgates. We've got First Amendment, the potential for this mingling with a First Amendment presumption that people can spend what they want on campaigns. We could keep going on and on and on with it. But the bottom line is that this accusation from Cohen that some of this was directed directly by the president certainly changes the narrative.
It does. And just based on what was said in court yesterday at the Rule 11, the guilty plea hearing, and the documents that are filed, it suggests that there was a conspiracy between at least Mr. Cohen and Donald Trump, just on what we heard in court. And I got to tell you this. I worked for the Department of Justice for a long time, 30 years, and we used to do prosecution memos. Mm-hmm. And you needed to satisfy two hurdles, or get over two hurdles. Do you have a prima facie case of a crime? And two, do you have a reasonable probability of conviction? Yesterday, what was filed and what was said in the court clearly satisfies a prima facie case of a crime committed by the President of the United States. Is there a reasonable probability of conviction? If you could indict the president while he's in office, that's an open question. But that first hurdle...
It is.
It is.
But the first prong you say was met. Well, look, we need to wrap this discussion up.
Easily.
Gene Rossi, former federal prosecutor, I know that you're involved in this case. Look, I understand the professional conduct rules just as well as any other attorney, so I understand that you have to be a little bit limited with what you can say, but we appreciate your insights very much.
Thank you, sir.
We are going to take a break here on the Law and Crime Network. When we come back, we plan on bringing you back to the Texas courtroom where a police officer is being tried on murder charges. We will be right back.